98, People versus Frederick. Counsel, go ahead.
I'd like to have 3 minutes for
3
rebuttal.
minutes. You have it. Go ahead.
With my remaining time today, I'd like to try to split it between the two issues in the case. As to the first issue, there was simply no statutory authority that permitted the court to resurrect the previously dismissed felony murder charge. And in fact, I don't read the people's brief as suggesting that there was any statutory authority. Instead, the people suggest that it was permissible because no provision of the criminal procedure law prohibited it.
So what's wrong with that argument? What's wrong with that argument?
There's two problems with that argument. The first is this Court has repeatedly held that the criminal procedure law regarding the grand jury formation and process is a comprehensive statutory scheme that leaves no room for judicial creation and intervention.
That can't be literally true, can it? I mean, no scheme is so comprehensive that a judge doesn't have to think something up occasionally.
You have to think it up within the statutory scheme.
But doesn't the judge, isn't it obvious that the judge has certain inherent powers?
I don't think that the inherent authority is properly invoked in this circumstance.
So once Judge Yates, I think it was Judge Yates who arraigned him on the superseding indictment, once he arraigned him and dismissed the original indictment, then Judge Zweibel was without authority to resurrect it?
Then there's a specific provision of the criminal procedure law, section 210.20, that governs what happens when a motion is made to challenge the superseding indictment and what actions are allowable thereafter.
So what should have happened here?
What should have happened is the people should have heeded this Court's warning in Franco and, in the first instance, not pursued this dangerous
What was the harm that took place? What happened that's bad here?
Mr. Frederick stands convicted based on a jurisdictionally defective and, frankly,
Wouldn't you see this is almost a perfect example of a kind of a technical view of this that kind of doesn't use common sense?
I don't think
Why couldn't the judge just correct this? Why doesn't the judge always have the inherent power to do this?
I think you're asking two things there. In terms of the
go ahead.
harm, I think that this case is very much like the Perez case, where, a clerical error meant that a charge was left out of the indictment, and this Court said, no, the Court can't write it in.
Well,
that technical defect is damning to
If
that.
on the second trial or third trial, whatever it was, if there had been evidence that could possibly support the lesser included, couldn't the people have asked for that if he had been prosecuted under the original indictment anyway?
They couldn't have, the charge at issue was felony murder, and the
Right.
manslaughter wouldn't be a lesser included of that, so
Right.
they couldn't
Right.
have asked for that.
Suppose a judge, the defendant makes a motion to dismiss, and the judge grants it. Can the prosecutor make a motion for reconsideration, say, Judge, you made a mistake, you overlooked this section of the statute, and they say, oh, you're right, I vacate my order?
Absolutely, and I think that would be a proper use of the
Does it say-
Court's inherent authority.
where does it say that? It doesn't say that in the statute. That's inherent power.
That's inherent power, and that wouldn't be in contravention of the statutory scheme. What's different here is it's in direct contravention of 210.20 sub 4, which restricts what the people could do after the Court dismisses an indictment.
Okay, but in my hypothetical, the Court dismisses the indictment, and then he undismisses it. And if you read 210, whatever the section you just cited literally, he can't do that, can he? I mean, he said once it's dismissed, it stays dismissed.
But that's the Court reconsidering its decision to dismiss the indictment. That isn't what happened here. I mean, the Court properly dismissed the superseding indictment, at least the felony murder charge in the superseding – I'm sorry, at least the manslaughter charge in the superseding indictment as violating double jeopardy. That dismissal couldn't be reconsidered or wasn't reconsidered.
No, but he's correcting a mistake. Why doesn't he have that power?
If any mistake was made, it was a mistake when he dismissed the felony murder charge in the superseding indictment, and that he didn't correct. The defense gave him the opportunity to correct that. He refused. He said, no, I'm going back, I'm resurrecting the original indictment. That he couldn't do because that dismissal was...
Isn't that a difference without a distinction? Effectively, how is that any different? And if he said, no, yes, okay, right, I will do that, we'll just proceed on the felony murder. I'm not going to call it resurrecting.
It goes to this Court's rulings that a valid indictment is a non-waivable jurisdictional prerequisite. Whoa, we're having a hard time spinning that out.
Mr. Frederick should have been tried under the superseding indictment with the dismissed count, manslaughter gone, just under the felony murder.
Once the people chose to go the route they did, that would be the only way to proceed.
Except I thought at the trial court, the defendant also argued that the entire superseding indictment was a nullity and had to be dismissed.
He did.
So it seems to be somewhat contradictory from what you are proposing now.
He cited the statutes, the double jeopardy provisions. You know, it was up to the court.
So he asked the judge to dismiss the whole thing.
And it's, of course, up to the judge to read the statutes and comply with the rules. The defendant pointed out this problem immediately upon the judge attempting to resurrect.
That's because he had already been tried on some of the counts of the original indictment.
Correct.
And that's why, supposedly, there couldn't be a superseding indictment, because the original indictment was still there. The trials had started. There were verdicts on some of the counts, and this was the only remaining count.
It's certainly why the people could not add the manslaughter charge at that late time.
So you get what you asked for, but it's still wrong.
Well, the defense immediately...
Is that the argument? I'm trying to understand why the flip-flop.
I mean, I think defense counsel recognized properly that there was no provision to resurrect the initial indictment. The defense counsel never proposed the resurrection of the original indictment. The people never even proposed that. The people pondered upon the court announcing that the entire superseding indictment was dismissed, how they were going to go forward. It was at that point that the parties, and particularly the court, had an obligation to figure out how to go forward. How they couldn't go forward was the way that they went forward, which was a resurrection of a dismissed count with no statutory authority and in direct contravention.
Could the court have given the people permission to represent? Now that there was nothing before the court, the first indictment had been dismissed, the superseding indictment had been dismissed, could upon application of the people, the court give them leave to represent?
And that depends on the basis of the dismissal for the superseding indictment, because then we'd be looking at, again, the statute 210.20, and depending on the basis of the dismissal, there's two remedies. One remedy is that it's a complete bar to any further prosecution of such charge by indictment or otherwise, or if it was a different type of dismissal under that statute, there's a provision that would permit the people, upon request, to seek representation.
When you get to the consecutive sentencing, I don't want you to...
Thank you, Your Honor. In this case, consecutive sentences were not allowed. This Court's ruling in Parks specifically holds that whatever underlying charges for felony murder must be run concurrently with the felony murder charge itself. So we know the burglary charges...
Assume you're correct about that. What about, could the judge have run the attempted murder and the felony murder consecutively?
That's the next question.
Adding up to the same 45 years.
That whether that would be allowable, and that's not, because we look to, as this Court has always recognized, we look to the acts. We look to the actus reus, and if the actus reus is the same, then consecutive sentences cannot be imposed. Now, the people posited different views of why Mr. Frederick was guilty of felony murder. One of their arguments, one that they introduced in opening statements, argued throughout the trial, and argued at summation, was that Mr. Frederick was guilty if he did nothing other than stab Ms. Aragosa, and that so scared Mr. Marconi that he made an effort to escape out the window, tried to reach for the fire escape out the window, and fell to his death.
Could the jury have found that? I mean, didn't she testify that more than that happened? Maybe not a lot more, but something more?
Sure. The people had other theories.
Well, was there a reasonable view of the evidence on which nothing happened except the stabbing of the female victim?
I'm not quite sure that's the standard that this Court has set out. When we're talking about the lawfulness of consecutive or concurrent sentences, the standard is whether the verdict might have rested on some other basis. And where here the people argued multiple bases for the verdict on felony murder, and one of those bases had the exact same actus reus, then consecutive sentences are not allowed. As for the specific evidence that the people argued that would have supported an intentional act, even though there was no intentional charge here, that evidence was highly disputed. Sure, the medical examiner testified that there might have been a stabbing, and she opined that there was a stabbing of Mr. Marconi. That was a little bit different.
Isn't it, on this whole record, isn't it quite far-fetched? We don't know what happened, but isn't it very, very far-fetched to think that he stabbed the woman and then stood there calmly while Mr. Marconi jumped out the window?
Whether he stood there calmly or not,
calmly
I'm
or not
sure.
calmly. It's very hard to believe he was not somewhat angry with Mr. Marconi, and he had a knife, and he had just shown the capacity to use it. Can we really believe that he did nothing except watch while Mr. Marconi went to his death, and that all those wounds on Mr. Marconi were inflicted by the screen? I mean, isn't there some limit as to how much imagination we can use here?
The medical examiner themselves testified that all of those wounds could have been caused by the fall out the window. We don't have any other evidence here. 2 juries hung on this exact question. It certainly wasn't an overwhelming case of an intentional act against Mr. Marconi. The charge wasn't even an intentional act against Mr. Marconi. We simply don't know what occurred in that apartment. One of the people's views was that nothing occurred other than the stabbing of Ms. Aragosa.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors. With respect to the first issue, the felony murder charge always remained a substantively viable, and therefore the defendant was properly retried on and convicted of that charge. Defendant suffered absolutely no harm from going forward, and that was the correct.
Is it your claim the felony murder charge was never dismissed, or that it was dismissed and then validly reinstated?
It was dismissed and then validly reinstated. And I'd just like to make a couple of.
Which indictment would the defendant have been better off going to trial on?
It made absolutely no practical difference from what indictment he went forward to trial on. I don't think it made any practical difference.
Well, then why did you? Right.
Yeah. With respect to the felony murder charge, the people concede.
No. My point is this: if the defendant is making a motion, as he's entitled to do, to say that this superseding indictment is defective, knowing now, if we were to find for you that he does that or she does that at their peril of having the old indictment reinstated, we're really taking away a right, aren't we? I mean, he would have been better off saying leave the manslaughter in.
No, I don't believe he would have been better off with an additional charge, that the jury could have compromised on an additional lesser charge. So I do not believe that he would have been better off. I also would like to make one point, which is one point of disagreement between us and defendant is whether or not this prosecution really could have gone forward on the felony murder count in the second indictment. And we submit it really couldn't have, because that would have ignored CPL 40.33, which says.
So why did you seek it? Why did you seek the superseding indictment?
We made a mistake. And other courts have made, other prosecutors have made mistakes. There have been other cases with this. We had cases from the first department, the second department, the fourth department. The question is, should a mistake about the procedures where the defendant doesn't suffer any substantive harm result in somebody getting away with murder. And
No,
that's
you
what happened in this
you didn't say you made a mistake. You opposed their motion totally.
We did, but now on appeal, we acknowledge that we should not have gone ahead and gotten the additional manslaughter charge. I think that the statutes are somewhat confusing, so you can see how that mistake was made. But I just want to go back to the point. I mean, how could we have gone ahead then on the felony murder charge under superseding indictment given CPL 40.33, which says that we're limited to going ahead on the original indictment? So then what you have here is a situation where because the people in good faith, there's no sense of any good faith, sign of any bad faith here, made a mistake, the defendant, who was subject to a perfectly valid retrial on a perfectly valid charge, ends up getting away with murder and can't be prosecuted. That just doesn't make sense. It doesn't further any policy.
And what about the application to the court to represent?
An application
Could have made an application to the court to represent.
Well, under defendant's logic, I believe defendant would say we couldn't do that either because he's saying that the dismissal was under 210.20 subdivision 1H, and he says that in that situation, the court is not authorized, doesn't have the power to authorize representation.
Is he right about that?
I believe that, no, I believe that he is wrong about that.
You say you could have represented.
I believe we could have represented, but that would have been what would have been the point? That would have been we already had 3 trials in this case, 2 grand jury proceedings, a victim. What would have been the point of having yet an additional proceeding when there was an indictment that was only dismissed to begin with as superseded?
How long do they last? I mean, how many dismissed indictments are there out there now that you could at some point say we want to bring it back?
No, we're not just saying, this is only in the situation where the indictment was dismissed as superseded by an indictment that subsequently is determined to have been unauthorized. We're not saying in general. This is this very particular situation. It makes common sense. There's no harm that accrues to the defendant, and there's no double jeopardy problem.
Could I mean, I don't want to interrupt, but at some point I would like you to switch to consecutive sentencing. Are you?
Okay. If anybody, does anybody have any further
Go ahead.
questions?
Continue. Consecutive sentence. Go ahead.
Consecutive sentence.
Can you distinguish people against Parks from this case?
Yes. I can distinguish People versus Parks 2 ways. First of all, here, as Your Honor was suggesting, it was proper to have the felony murder count run consecutive to the assault and attempted murder count.
What about to the burglaries? Or to one of the two
Well,
burglaries?
now, on one level, that shouldn't matter.
I understand it shouldn't, but nevertheless, but the judge did it. He said this is the murder count runs consecutively to one of the burglary convictions.
He made the, yes.
Was he, I mean, I understand your point that you can get to the same number of years a different way, but was he wrong or right to do that?
He was right to do that. And, in this case, we certainly know what the fact finder found here with respect to this, whether there were separate acts. And, obviously.
You know which predicate he found? Or they
well,
found?
we do because the fact finder was the judge. This was a judge trial. And the judge made comments at sentencing. And in those sentencing comments, the judge makes very clear that he found that after the initial attack on Aragosa, the defendant proceeded to turn his anger and his rage on Maricone and go after him with a knife. I'm reading from page A142. The judge said, and again, he's the fact finder as well. He says, the strong circumstantial, he said, first, after stabbing Miss Aragosa in the neck and believing you killed her, you continue your rage against Chris Maricone. The strong circumstantial evidence was that you then proceeded to stab Chris Maricone in the neck as he attempted to fend off your attack, as evidenced by the defensive wounds on his, and I think it says neck, but it should be hand. Therefore, we know here, and he also says that the wound, talking about the wound to the neck, he says, we know that wound was made with a sharp object consistent with the knife he used on Ms. Aragosa. So the main reason this case is different from Parks is we know here that the fact finder found that there were separate acts, that the burglary that involved the injury to Ms. Aragosa was complete and was based on a separate act from the felony murder of Christopher Maricone, which was when he was trying to flee from.
Did he say which felony he was predicating the felony murder on?
Well, I believe that is implicit in the analysis, the statement that he makes at sentencing. And again, and that's what the trial evidence shows. And that's what the people argued at sentencing.
Maybe you can just infer, since he was the fact finder, maybe you can infer that he knew enough to run it consecutive to the one that was not the predicate.
Right. So it was a proper sentence. He made it consecutive. I mean, this was a case, if ever, you know, you have a defendant who kills two victims through different acts. There certainly were very many different acts in this case. And both judges crafted the sentences to make what we wanted in this case, what the court wanted to impose and what we submit is proper, is for there to be separate punishment for the horrible injuries and wrongs done to two separate people through separate acts. Justice Yates did the same thing in the first sentence by making the sentence on the burglary count for injuring Maricone consecutive to all the other sentences. And that's why he now has a 30-year to life sentence. Not on a 30-year sentence, I'm sorry, not 30-year to life sentence. I submit that if defendant prevails here, he would probably go and question that too, and would try to end up with just a 25-year to life sentence. That would be grossly unjust in this case, given what happened, given that the separate acts. So in both, with respect to both issues, defendant is really trying to take advantage of technicalities to escape responsibility for very heinous crimes. It took a long time to get a measure of justice for Christopher Maricone. That was the only reason they went ahead to the third trial. And we ask that that measure of justice be respected. Thank you.
Okay, counsel. Rebuttal?
The people's errors here were not merely in seeking to violate the double jeopardy rule by trying to get a superseding indictment in first-degree manslaughter. They also sought a superseding indictment on felony murder in direct contravention of what this Court suggested the better practice was in Franco. There was no need to do that. That felony murder charge was perfectly valid until they sought that superseding indictment. And then they further erred in not objecting when the Court dismissed the entirety of the superseding indictment, including the felony murder charge. Now, we do disagree as to the meaning of CPL 4030. That is not a statute that is a restrictive statute that invokes double jeopardy. That's CPL 4040. 4030 permits the people to retry someone after a mistrial or if a plea is vacated. That's merely the impact of that statute. It does not preclude a superseding indictment on the same charge that the mistrial had already been declared on. In fact, this Court has held as much in the Leyra case, where there were two trials before the people sought a superseding indictment on the same charge, and that was permitted to go forward. There is no problem with seeking a superseding indictment on the same charge. It may be an odd way to go. It may be a dangerous way to go, as this Court has pointed out in Franco, but it would have been the only permissible way to go here. That isn't what happened. You couldn't resurrect that dismissed charge in direct contravention of CPL 21020 sub 4. As to the sentencing point, the dispute between the parties really narrows down to whether or not there were different acts proven at trial that formed a basis for the felony murder conviction. I don't think you could ascribe a comment made by the court about the circumstantial evidence as indicating that a knife attack on Mr. Marconi was proven beyond a reasonable doubt. Here, the people argued that Mr. Frederick should be convicted if all he did was stab Ms. Aragosa, and that prompted Mr. Marconi to try to escape from the apartment. That's one actus reus. Concurrent sentences are not only appropriate but are demanded by 7025. They are also separately demanded by 7030, which we haven't spoken about at all. And my time's up, but it's a totally
Thank you,
distinct
counsel.
argument. Thank you.
Thank you both.